not that way, my lord, adversarial in that sense.
So because now after we break today, tomorrow is miscellaneous. Monday, Tuesday, my learned brother Justice Nasma is not in court. So we'll meet on Wednesday. So you have that time to, come back to us and respond on
Yes.
Wednesday.
My lord, shall I finish this or my lord, or do
No,
it?
no, you wap up on this now.
Please,
because-
please.
And you
Lord, kindly have this, my
done
lord.
it in
I'll
a
just
very-
quickly go through
Yes,
this, my lord.
let's quickly run through it.
There is no fundamental right to get all types of social relationships like marriage recognized and registered. There is no fundamental right. Well, that's the thirst and respectful, Lord, very emphatic submission on my part. Then Article 14 argument, Lord, while challenging the Special Marriage Act, they say the Special Marriage Act is violative of Article 14, Lord, to which I say, Article 14 applies when government has created a mechanism for different classes, though they are same, or vice versa, which is not the case here. Or act has no nexus with the object it seeks to achieve. These are the two ground, my lord, for Article 14, my lord. We may call it arbitrariness, we may call it by any other name, but broad categories are this. My lord, here the Special Marriage Act is only for heterosexuals. And that's what, my lord, the debate also clearly show, and the language and architecture also clearly show.
Yes.
And the object is intra-faith and interfaith, intercaste marriage. And it seeks to achieve that, my lord, and there is no provision contrary to that. So, when you want recognition of a particular class of people in a particular class of relationship, it cannot be said that the other class legislation is violative of Article 14. Well, that's the submission. Now, petitioner want a new class to be created. I have already made submissions for an entirely new object, which was never conceived at the time of, my lord, enactment. Now, my lord, there is no positive obligation on the state to recognize every social or personal relationship. There are a large number of relationships in the society. All need not be recognized. As a matter of fact, well, this is something very, very crucial. The state should be very slow in recognizing the relationship, because state is entering into the arena of socio-personal relationships. It can recognize only when it finds that legitimate state interest requires regulating them. And you can regulate only if you recognize them. So marriage also in heterosexual, ideally, should not have been regulated. But the society felt